lots of people flashing up in front of me, rather like Love Actually, the final scene. Just waiting for a few more people to join.
Morning. It is nice to see people actually, rather than just be talking to the dark. Morning.
Well, good morning, everyone. Some familiar faces here, and welcome to the opening session of Wednesday's mediation week. And we're here to discuss the Fair Shares report. I'm David Emerson from Anthony Gold. Most of my work is mediation, although I'm also collaboratively trained. I'm a part-time judge, so I see things rather differently there. And I chair Resolution's Dispute Resolution Committee. And we're looking at the Fair Shares project, that's sorting out money and property on divorce. It's a project funded by the Nuffield Foundation and undertaken by the University of Bristol. And we're going to have a video from one of the people who led the research, Professor Emma Hitchings from the University of Bristol, who's going to explain some of the findings, and then we're going to turn to our impressive panel to discuss what the findings are and what the implications are for people in separation, for mediators and lawyers and anyone involved in the legal services industry. Okay, so we have on video Professor Emma Hitchings from the University of Bristol. We have Dr. John Simmons, who's a senior lecturer in social work with children and families at the University of Bristol. And we have Dr. Rachel Blakey, the assistant professor in law at the University of Warwick. Those are the academics, and if I can put it this way, the non-academics are Mary Raymont, who has her own mediation business, Advantage Mediation Limited, and she sits on Resolution's Dispute Resolution Committee. Karen Barham, who is a consultant with Moore Barlow and practices exclusively in mediation. She's also on Resolution's Dispute Resolution Committee. And last but not least, Elaine Richardson, also from the Dispute Resolution Committee, and she's the co-vice chair, and she principally practices mediation too at Richardson Family Law. Okay, so what we're going to do now is we're going to move to the video. So if you'd like to sit back and relax and hear all about the research project.
Hello, and thank you for attending today's session. My name is Emma Hitchings, and I am the Principal Investigator for the Fair Shares Project. This is the first fully representative study of finances on divorce undertaken in England and Wales. So my plan today is to provide a brief outline of the project. This will include a couple of key findings on the financial context in which couples went into their divorce and the overall picture of how the couple's assets were divided. I'll then move on to look at the process itself, including the role of mediation. Finally, I'll outline my thoughts on what mediators can take from the research. Now, just to note for information, the report contains a huge amount of detailed information, which I will be unable to cover today. So please do refer to the full report for more detailed information. Now, so a little bit of background. Now, approximately 100,000 couples divorce each year in England and Wales, but of these, only around 1/3 leaves the marriage with a court order for finances. Now, approximately 90% of these court orders are by consent. The remainder are adjudicated. We know something about the court financial remedies population through previous research, such as court file surveys, but we have known almost nothing about the 2/3 of the divorcing population that do not go to court for a financial order. So the aim of the research was to provide the first representative picture in England and Wales of how finances and property are divided on divorce. In particular, to include information on couples who do and do not use the legal system for their financial and property arrangements. Now, the key difficulty for us from the initial design stages of the study was how to access the non-court population, those divorcees who do not get any financial remedy order on divorce. The way we did this was by commissioning a bespoke large-scale survey filled out by divorcees themselves. The survey was carried out by the research organisation YouGov, and this was done amongst divorcees within its online panel who had received their decree absolute in England or Wales within the previous 5 years. There were just under 2,500 online survey responses from recent divorcees. The interview sample was generated through a research agency who recruited individuals who had been divorced in the past 5 years, and these interviewees were purposefully selected to ensure inclusion of our key groups of interest. There were 53 Teams or Zoom interviews, and each of these lasted approximately an hour. So I'm going to start by setting the scene about the financial circumstances that divorcees were in at the point they separated or entered into the divorce process. Due to lack of time, I'll look at the overall assets only. So what we've got here is the total net value of the assets from the marriage, including the matrimonial home and pensions, savings, and other assets, with any debts deducted from the total. Overall, we found that the median asset value for participants was £135,000. And this number, this amount, includes those who had nothing or only debts. So what we've got here is quite contrary to the impression given by the media's reporting of big money divorces. Most divorcees did not enjoy lives of luxury during their marriage and had relatively modest amounts of wealth to divide at the end. We see from the top bar that nearly 1 in 5 had no money or assets to divide. Substantial numbers of others also had relatively modest levels of assets. So 3 in 10 of divorcees had total net assets of under £100,000. A third had assets worth between £100,000 and £500,000, and at the upper end of the spectrum, only 1 in 10 had £1 million or more. So overall, our findings here show that a large number of divorcees were in constrained financial circumstances at the point of divorce. So having briefly described the assets that divorcees had going into the divorce process, I'm now going to turn to how these were divided between divorcing spouses. This slide shows the percentage of the total assets that divorcees received, with our primary finding being that equal sharing of assets was not the norm. If you look at the middle bar, only 28% of divorcees reported receiving around half, and we classify this as between 40 and 59% of the total asset pool. A third of divorcees reported receiving a percentage share of less than 40%, including 3% who took on more debts than they received in assets, and a further 3% who received nothing. The interview data suggested that the reasons for divorcees sharing out their assets unequally reflected need, individual circumstances, and differing motivations amongst divorcees, such as wanting a clean break. There was no significant differences between men and women in the value of their shares received, but the differences instead were in the nature of the assets they received, with women were more likely than men to receive more of the equity in the home, while men kept more of the pension wealth. However, overall, divorcees who had higher value pensions, and that was men or women, tended to do better financially than those with no or lower value pensions. What this highlights is that the value of having a good pension when it comes to a divorcee's financial position post-divorce. So, moving on to process. This slide provides data on the use of lawyers and mediation. Half, 56% of divorcees consulted lawyers at some point during the divorce, but only a third, 32%, used lawyers in relation to their finances during the divorce process, with slightly more women than men. There were 34% of women and 29% of men. But also of note, with fewer than 1 in 6, 17% of divorcees reported having tried mediation. So let's look at the divorcees' experiences of mediation next. First, it is worth noting that some interviewees told us that they had not heard of mediation or had thought it only related to disputes over children, suggesting that there is still a significant level of ignorance about this option. Secondly, in line with other studies, divorcees' experiences of mediation was mixed, with some having a very positive experience, whilst for others, it had been expensive and/or unproductive. The importance of both parties engaging in the process, if the process was to be productive, was emphasised by the following interviewee on this slide. This wife said, "I think we had about 2 or 3 sessions of mediation, and then he refused to pay for any more. And what was agreed in mediation, he denied any knowledge of even discussing it. And so, I think that for me was one of the biggest flaws of this process. I just think it was a pointless waste of money that achieved nothing, unfortunately." But from our sample, we know that there were those divorcees who did not attempt mediation, and those divorcees who didn't attempt mediation gave a variety of reasons for not doing so. And these included communication issues, domestic abuse, entrenched views precluding negotiation, that they or their partner weren't emotionally ready for it. Other divorcees felt they had sorted everything out and there was simply no need for mediation, whilst for others, the issue was never discussed. So, for example, that is taken in the following quote of wife 6, where she said, "Mediation was never discussed because he would never have done it. You'd have got more information talking to a tree." Of those who had come to a full or partial arrangement overall, not just through mediation, but through any arrangement, which was 50% of the sample, the majority of these arrangements, 52%, were made by divorcing parties themselves. Agreements were reached with the aid of lawyers by 19% of participants and through mediation by 13%, with a noticeable proportion who were using mediation not going on to get a consent order. And you can see that in the bar graphs towards the middle where it says mediation, no consent order, and mediation, then consent order. Furthermore, what we found was that the strongest predictor of using mediation was having used a lawyer. 28% of those using a lawyer tried mediation, compared with just 11% of those who had not. Our study therefore confirms what was already known in the wake of LASPO, that lawyers are the main and the best sources of information about the utility of trying mediation. So whilst lawyers are perhaps the obvious and most common source of legal advice used by 4 in 10 divorcees, that's the top bar graph on our chart here, the data provides a rather mixed picture of where divorcees obtained their legal information and advice. As you can see from the bar chart, 29% had used government website, that's the second bar, with 12% obtaining their information from mediators. That's sort of halfway down the list. Perhaps also of most concern in this chart is the bottom graph, which is the finding that 12% said they had sought no information or advice about their divorce. So leading on from that, what this slide shows is that there was a lack of awareness of family finances amongst a significant proportion of divorcees. Some examples of this from the findings are over a third of divorcees not yet drawing their pension did not know the value of their own pension pot, let alone their ex-spouses, with women at 40% more likely than men at 34% to say that they did not know. 10% of homeowners with a mortgage did not know what the equity in their home had been at the point of divorce. And remember, the sample were those individuals who had gone through divorce already. So 10% had not known what the equity was in their home. And finally, 4 in 10 divorcees at 38% felt their knowledge of their ex-spouse's finances was bad or very bad. This lack of awareness and understanding of pensions in particular came through from the interviews as well. So for example, in this interview, wife 27 said the following: "He's worth an absolute fortune when he dies, but if there was a way around him not giving me any money, he would find that way. So I didn't look into it. If you don't know what you're missing, you don't mind." So in this case, the wife didn't look into the pension's wealth. And generally, this lack of awareness and understanding of pensions fed through, as one might expect, into how, if at all, pensions were taken into account when couples sought to make their financial arrangements. So on this slide, we examine how arrangements differed between those who did or did not use the court to formalise arrangements. However, it's important to emphasise that the data is unable to show that the process of formalising an order causally led to a particular outcome. Instead, the data can only show correlation between particular outcomes and whether the divorcee had a court order. Now, from the study, there is evidence to suggest that women tended to do better where a financial remedy order was obtained from the court, whether that was by consent or adjudicated. So, for example, some of the bullet points on the slide that are women were more likely to receive a transfer of the matrimonial home and less likely to make a compensating payment to the ex-spouse where there was a court order. Also, they were more likely to receive over half the value of the home if it was sold. And finally, they were more likely to obtain a share of the ex-spouse's pension. Now, while the study could not establish a causal relationship, it is plausible that legal oversight, whether through the court or through the provision of legal advice, appears to provide a potentially valuable form of monitoring which may protect individual divorcees, particularly wives, from potentially unfair financial arrangements. So our final slide before we go on to the conclusions is, did things work out as expected? Now, we asked survey participants who had made financial arrangements whether these had worked out as they had expected in terms of being implemented as agreed or decided. We found that arrangements made through mediation were less likely to work out as the divorcee expected. So some of the figures are here: 9 in 10, so 90% of full arrangements arrived at by the divorcing parties themselves had worked out as expected. Now, presumably, this reflects the better relations of those who had felt able to negotiate their own arrangements between themselves. Looking at the next figure, now 3/4 of full arrangements made via lawyers at 76% and all via a judge, also at the percentage figure of 76%, had also worked out as expected. But only 44% of full arrangements made via mediation had worked out as the divorcee had expected. Now, it should be noted that those undertaking mediation may also have tried and failed to negotiate an agreement between themselves, so that when they did reach a settlement via mediation, it may have been the result of possibly a compromise or even a grudging compromise rather than a real meeting of the minds, and thus potentially more likely to unravel when it came to be implemented and a party had second thoughts. So, what can mediators, moving on to conclusions, what can the mediators keep from the research? Well, first, divorcees' lack of financial knowledge and legal knowledge. Given the lack of awareness of family finances and legal knowledge amongst a significant proportion of divorcees, particularly in relation to pensions, we suggest that there is a need for authoritative, accessible, and affordable information and legal advice to provide couples with a clear understanding of the issues they should be focusing on, including the range of assets, including pensions, that can and should be brought into account, and how to reach a settlement with signposting to affordable and appropriate services to help them. So, the second element here is the use and benefits of the family justice system. In particular, tailoring methods of dispute resolution to different divorcees. Now, as we found and as we saw from the figures, mediation was not the most popular avenue to pursue, with only 17% of divorcees saying they had used it and only 12% reaching an agreement by that route. And also on that, one of those last slides, we found that only 44% of full arrangements made via mediation had worked out as the divorcees expected. Therefore, I think what those figures show is that individuals need appropriate dispute resolution tailored for their individual circumstances, which in particular, which addresses the problem of relationships where there is domestic abuse and or lack of bargaining power. Mediation is appropriate for some people, but it won't be appropriate for all. Also, what the research shows is a need for consent orders, the importance of consent orders. Now, where parties' financial and property arrangements had been finalised through a court order, women, as the data showed, tended to do better in a number of respects. The role of the court, therefore, not as a rubber stamp, but as a guarantor of the legal efficacy of the couple's agreement, is therefore an important one that needs to be safeguarded in any reform of the system. Indeed, the benefits of certainty and finality that come with a consent order, as well as the opportunity to check the fairness of the arrangement, suggest that more should be done to encourage couples to obtain one, even when they are in full agreement. And finally, the last range of bullet points on achieving a fair outcome and in terms of what mediators can take from the research. So first of all, the importance of pensions. Our data showed that there was a general lack of interest in the pension and also a strong sense that it should remain with the spouse who had been contributing to it. And these were the main reasons for the failure to see the pension as a potential sharing resource in most divorces. It's therefore not surprising that offsetting in the form of trading shares in the matrimonial home was the preferred alternative for many couples. However, this does not adequately redress the imbalance in the total pool of financial resources available to the husband and wife. Neither does it redress the differences in divorcees' living standards up to 5 years after their divorce, which is an issue I have not had time to cover today, but which is included in the full report. It's clear, therefore, that both parties to a divorce need to be made aware of the potential importance of pension wealth as part of their entire asset pool. And finally, the last point is managing expectations of clients regarding the mediation process. Now, when it comes to those who have attended mediation, the findings show the divorcees' experiences of mediation were mixed and outcomes were not sometimes as they'd expected. Managing divorcees' expectations before the process of mediation commences is therefore an important takeaway for mediators from the research, underlying what mediation is, what it is not, what it can do, what it cannot do in terms of the process itself. So for those of you who would like to find out more, the final report, the executive summary and the briefing paper are all available open access if you follow these particular links. Thank you very much for listening.
Well, isn't that fascinating, the study and its findings? And I suppose one of the unique things is that we've got this study in the first place. And I wonder if I can ask you, Mary, that must be a positive in itself.
Well, I think so, and we're very grateful to University of Bristol and everyone involved with this at Nuffield to have done this piece of work, because we need to know this information. Of course, it may have moved on a bit since it was, because I know the report was over the last 5 years, but we can take this information, take these conclusions and really work with them and try and tailor what we do now to meet the gaps that we can clearly see.
Yeah. So, Rachel, you must be very pleased with the way it's gone, the way it's been received. What do you think the positives are from what the conclusions are?
Yeah, it is worth just clarifying to everyone here that I wasn't directly involved in the FairShare project, and John wasn't either, although John has worked with Emma. So we can discuss the findings generally, but I won't be able to tell you any specific bits. I think for me, as someone who researches family mediation, I do consider it a very under-researched area and a profession, particularly in the last decade or so of LASPO, where we've seen mediation becoming really important in our family justice system. And I think more needs to be done on uncovering what happens in the mediation room. I think for me, what really stands out from the project is this, the low number of participants who say that the mediation agreement actually works out as they intended. So my work is not about people's experiences of mediation. Instead, my research is based on talking to mediators. So I interviewed mediators. It means my findings are more about mediators' own perception of how things work. And what's quite interesting is I think most of the mediators I spoke to did feel mediation could be attempted in a lot of cases, and they felt mediation could be adapted. And we see this almost inconsistency or this contradiction when we then speak to people who have gone through the process. And we don't have any substantiated reasons as to why it's definitely a thing for future research. But it would, to me, the FairShare starts to shine a light on that, of what perhaps might not be working and what also is working, and then what can we do in light of that.
Okay, so I mean, I think the statistic is 44% of those who went through mediation felt that how it turned out was not as they expected. Is that a cause for concern, or is there something positive there that the mediator was able to change people's perspectives? What do you think, John?
Yeah, thank you. I think the two things that that came out to me which relate to that are the lack of knowledge, really, and information that that couples first of all knew about before entering the process, and then about the amount of information that they had potentially about kind of the process. And I think that might go part of the way to addressing some of the points that Emma made about whether or not it met their expectations. Like Rachel, I didn't work with Emma on the FairShares project, but we worked on a different project speaking to families about the process of separation and the support they'd had, whether that was from family or friends or solicitors or mediation. And one of the things that parents told us about when mediation didn't work for them was when the mediator challenged, or in this example, didn't challenge the unrealistic expectations of one partner, which meant that they had to go to court before they got it resolved. Now, when it went more positively, parents said that mediators were taking much more of a lead in the meeting and being more directive and giving realistic advice about what couples might expect, so that when they did get an arrangement, it was something that might not have been what we wouldn't have given each partner everything of what they wanted, but they kind of recognized that it was enough of it to make an agreement work. So
Yeah.
I think there's something about kind of managing the dynamics and managing information and managing expectations within them.
Karen and Elaine, I wonder if I could ask you, what are the difficulties being a mediator and maintaining neutrality, independence, impartiality, but also introducing information about, particularly about the law, about fairness and outcomes and so forth? Karen, do you want to go first? And
Yeah, I'm very happy to. I assume from these findings that the 44% that were asked said that the mediation, the outcome hadn't quite worked out as expected. I'm assuming that actually perhaps the outcome was worse than they had expected, rather than 44% thought, gosh, this is absolutely amazing. This is way better than I had expected. I understand from our academic colleagues here that, as John has said, a mediator that is perhaps more directive in terms of giving information, etc., was welcomed by those that were asked. Of course, we do know, don't we, that the importance of the relationship between lawyers and mediators is absolutely crucial. But for me, and again, this has been found by our academic colleagues in the mapping paths and creating paths to family justice, is where people get their information. So a real takeaway for me is that single point of reliable information. I also understood from our colleagues here that they were less interested about the mediator's origin, that, you know, previously they were a lawyer, a therapist, etc., but that they needed a sense that they were in safe and professional hands, and that person could be more directive when asked. And for me as a mediator, I always ask permission of the clients, might it be helpful if I give you an indication as to where I think the outcome might safely land? And my understanding from the research and talking to our colleagues here is that that is what clients tended to find most helpful.
yeah. Elaine, what do you think?
It is a continuing challenge and concern about delivering good information to mediation clients in a way that's not seen to be partisan. And so I'm a great believer in the handout, the good old handout. Now, the next problem with the handout is you send it as an attachment. Does somebody actually read it? So there's a benefit in repetition, I also think. So, you know, send the handout, then come back to it in the mediation meeting and say, you know, this is a really valuable information. It bears repeating. I'm going to go over it again. But it's also, I think, that encouragement for people to go and see lawyers and take their own independent legal advice where they haven't done so. And that also can be a challenge, because people obviously are very concerned about saving money. There's, I know a question came up yesterday when we were doing the high conflict personalities presentation about whether adding lawyers into the mix just makes things more confrontational. So again, it's going back to Karen's point of mediators and lawyers very much working hand in hand. I know that Bill Eddy's response to that question was, you need to find lawyers who possibly also are members of mediation organisations, because you'll know that that lawyer is then committed to the mediation process. Anyway, just a couple of points.
Thank you, Elaine. Beverly Sayers, you had your hand up. You wanted to make a point.
Yeah, I think there's some really interesting outcomes from that research, that study, about how mediators can help clients with expectations, and in particular be clear about what mediation can and can't achieve. And I think we need to listen to some of those messages very clearly. However, this particular aspect about was not what they expected, or whatever that statement was. I'm very unclear what that means. Is that they got an outcome from mediation and then that wasn't what happened in court, or was that they came into mediation, as many of us as mediators will know, they came into mediation expecting that the house would be sold and then discovered there was a different solution? I'm not at all clear about what the definition of that was, that particular finding, which was it was not what they expected it to be. I think we need a bit of clarity on that.
Yeah, there's a very good case by the senior financial remedy judge, Peel J. I think it's about a year or two ago. I can't remember the name, where he really takes you through in his judgment what the process is for analysing a financial case, how you apply the law, how you start with the presumption of equal division of assets, how you apply Section 25. And a lot of his colleagues have called it the Noddy Guide, which I think is a little unkind. But perhaps we need him to do a sort of short video version of this that can be played to people participating, because it's clearly would be an impartial summary. It's not giving them answers to their particular questions, but it explains the process. John, if I can ask you again, please, what do you think are any other concerns that the report's findings throws up?
Well, one of the thing that I was that I didn't say in the first answer, I suppose, is the degree to which the financial arrangements and pensions have not really been the subject of so much attention, or certainly discussion between the parties. And I think it was interesting that when they approached, for example, mediation, didn't fully understand that pensions might be a part of that discussion and the financial arrangements. Again, the findings that Emma described in relation to that echoed some of the things that parents told us in our own interviews about kind of differences in the factors in making those decisions, about whether you just wanted, as Emma described it, a clean break in the relationship and to have nothing more to do with your ex-partner, so not wanting to negotiate pensions, versus understanding that your pension might actually be quite valuable in the long term, and that it's worth holding on to for if you can negotiate that. And I think Emma drew that out really nicely in terms of how that helps us understand some of the process around negotiation between couples. Yeah.
And you see in the chat, a couple of people have made links with the Family Justice Council sorting out finances and their needs document, and someone has confirmed that the case I'm talking about is WC versus HC 2022. Was there any sort of an analysis of how coercive and controlling behaviour and domestic abuse generally might have featured in the study? Rachel or John, one of you wants to take that? I know you weren't directly involved, but you probably know the detail far better than anybody else.
Yeah, from what I know off the top of my head, not particularly, and this is actually a really big gap we have in research in general, and I think that's outside of mediation as well. we have, you know, initial evidence to suggest obviously it makes negotiations incredibly difficult. But it is unfortunately somewhere where the data is lacking. Probably again, when, especially in mediation, we haven't had a lot of funded projects looking at it. You know, in Fair Shares, for example, it's still one small part of a really big study. But I don't know if John wants to add any more to that as well.
Yeah, maybe just to flag up the work of Anne Barlow and Liz Trinder in this field as well, who have kind of done some really important work touching on these areas. We had a relatively small group of parents who had experience of mediation, so I wouldn't want to draw any generalizations from it, but for some of them, one of the issues in the sessions was around kind of managing kind of power dynamics or negotiation tactics between the couples and the extent to which the mediator was able to recognize and intervene in those. That was certainly a characteristic of maybe when things went well. When in the very small number of examples we had where there had been domestic violence in the relationship and they had experience of mediation, then the mother that we spoke to had a very negative experience and found it quite kind of re-traumatizing. I know that there are a number of different models of mediation that are getting developed, and I think there's a kind of a book that's been produced kind of laying out different models, which is getting made available. And I think the more that couples are able to understand the different options available to them and to make decisions based on their own circumstances, then the better chance there is of them getting kind of the effective support through that process.
Elaine, you present courses for resolution on domestic abuse for practitioners in undertaking all types of dispute resolution, including the court-based. Anything you want to say about domestic abuse in relation to this report?
Yes, I think obviously the go-to for everybody is to do no harm, and that's certainly the beginning and end of our training. If people just remember that one thing, it's to do no harm. But it's also about participants in mediation, particularly the victim survivors, feeling as though they do have a choice. And if that's done safely and done with an experienced and fully trained mediator, it can be better than going to court with an abuser. So I think that's a really important point to make. I'm not saying that mediation is for everybody. All mediators know that. We'd love to wave our magic wands and make that something that could happen, but we know realistically that that's just not practical. That's not the case. However, I do think that there is a real opportunity here with further training to be able to give people, victim survivors, different options other than just going to court with an abuser. And I've certainly heard some terrible stories about going to court with an abuser that have not worked out in the way that the victim survivor would have hoped for. So it's about developing options, I think, and it's a really interesting area where, you know, I think that there's more research that could be done, and there's certainly more training that could be done.
Mary, can I ask you, I think the statistics tended to show that lawyers were a primary source of referral to mediation. But what's your view on that, and how has that changed over the years?
So I think it's really fascinating to know that, actually, and I think it's really useful for anyone working in the mediation world to be aware of that, because perhaps one of the immediate takeaways is that mediators need to strengthen their links with lawyers and make sure that lawyers are fully educated in what mediation involves. Just as an adjunct to that, obviously in this country, we practice facilitative mediation. We do not practice directional mediation, that is the Australian model. So it's so important that our lawyer colleagues understand that we are not going to give an opinion, that we're not going to give advice, and also getting that distinction for clients to understand that we're not actually treading on the lawyer's toes, because we're not advising their clients. I'm a lawyer myself. We're giving information to people. So I think it's really pivotal that we as mediators have really close links with lawyers and understand what we do. And there's been reference to all the different models that we offer, the different people that we work with. We're like project managers, you know, we look at the team around the client. We look at, you know, does this person have an IFBA? Do they have an ISPA? You know, there's new rules over the last 12 months of, you know, IFBAs being able to go in and support people within the court environment. You know, that's something that we could really be looking at. You know, obviously safeguarding is so pivotal. It's absolutely fundamental. As Elaine said, do no harm. But I think it's really important that we are able to educate lawyers in what we can offer and what we can't offer, and making sure that it's suitable. One thing I would like to mention as well is that I think it's really important that I know Elaine is involved in this. The structure of our intake meetings has changed dramatically over the last couple of years as mediators. Had a lot more guidance coming out from the Planning Mediation Council now as to the sorts of things we should be covering with clients. So again, I don't know whether lawyers have that information, and also, and I suppose I sort of really direct this to Rachel and John, is, you know, it may be useful for you to do further work just to see the impact of those additional structures we now have on our intake meetings, because there's a raft of targets we have to hit within those meetings that weren't necessarily spelt out so clearly. So I think it's never developing field, but I do think that now that we know this, we know that lawyers are a primary source of what we do. We need to make sure that we, well, first of all, that we make sure that we work closely with lawyers and educate them, but also I'd be interested, John and Rachel, to hear from you as to, you know, how can we as mediators diversify those pathways, because, you know, that is a really pivotal thing that I think we as mediators need to understand too, that really those pathways should be coming from so many different other avenues. And in Kent, we have the Alliance, and we have a website, and we've got charities, local organisations for mediation, the Kent Hub. It's a resource, but how do we improve the pathways, given that we now know that lawyers are a primary source of pathway? How can we diversify? I don't know if you've got any views on that, John or Rachel.
I have views on everything. I think a big
You can
thing
have
is
your
just
own
public
show, Rachel.
awareness. Well, it is worth saying. I'm writing a book on all of it. It's a shameless plug, I know. And I do have articles that if anyone's ever interested in things, you know, do give myself or John a message and we can, you know, send links to things. Public awareness of mediation in general is very low. And we've seen those figures, the same kind of figures over time, really. I don't think there's been anything, you know, in the last decade or so. But I think that's a problem. And that's a wider issue to do with campaigning and things like that. I think it's also worth mentioning that people are going to a wider variety of services and organizations for advice and support now, because people can't necessarily go that traditional route of a lawyer anymore. Things such as even online services and whatnot, and whether there's something to say that mediation, whether family mediation services and their members can have more of a relationship with them. And then you might see referrals coming from those new different professionals as well. But I think as I said at the start, I think part of it comes down to public awareness around mediation, and also misunderstanding, as Emma mentioned in Fair Share, as people still don't understand what mediation is. And public education and campaigning, I think, is a really big thing.
Yeah. I mean, it is interesting still to look back at that statistic, and I can't remember what year it was, but just where referrals to mediation just fell off a cliff when legal aid was removed, because lawyers and legal aid lawyers in particular were the primary referrers of cases to mediation, and that just still hasn't recovered at all. I see in the audience we've got Mavis McLean, and yes, you, and I, who brought out a book 4 or 5 years ago, which touched on similar issues. Mavis, I just sort of wondered whether you had any thoughts in relation to the findings and what was in your original studies. You're on mute, Mavis. Yeah, you're on.
I do beg your pardon, I'm being very modest. It's wonderful to hear you all, and sorry not to be with you. But I think, what we found, which was a little while ago now, was the problem about information. When I first began to look at people entering the divorce separation pathway, I first of all observed solicitors, and when people came in, they first of all asked, what do most people do? What and then would be told the kinds of things which are possible, and then they would say, well, what should I do? And the solicitor would say, well, this would help in this way, that wouldn't work because of X. And a plan would be formed, and then the solicitor would say, the client would say, well, what do I do next? And they would take the next step. And it was that sort of structure of where do I stand in this terrifying new world of separation and complication. This, basically they seem to be asking, what's the social norm? What should I do? But couched as what do most people do? And I always feel that while mediators are being very careful not to give legal information or advice, the boundary between the two being still very difficult to define, would it be possible to go a bit further with the what do most people do sort of conversation?
Yeah. Okay. Can I throw this open to anybody, actually, just how you think mediators might improve the way they give information about the law to those participating in mediation, and particularly when you have people who don't have lawyers in the background? Anyone want to take that? I will go back to the panel.
I'll go. I think. Can you hear me?
Yeah.
Yeah. Because I'm a newbie mediator. I've only been doing it for a couple of years, but I think it starts at the MIAM to give information and links following the MIAM. And then I like Elaine, what she suggested is doing a summary. And I listened to Eddie yesterday, and he was saying, to keep on emphasizing and to go back and give a little, I think he called it a seminar. So maybe that's what we should be aiming to do. But that's my thoughts anyway.
Yeah. Karen,
sorry, David, Nigel here.
Nigel?
I'm not a mediator. I don't know whether mediators do this. I probably should. But what about some sort of template case studies, if you like, putting people's names in it, but obviously anonymized, as to the kind of outcomes that cover a range of typical issues, so that it looks a bit more personal than a sheet that just says blank information. But it's actually, so Fred and somebody else did this. This is what happened here with the pensions, just to sort of humanize it a bit more.
Yeah, no, that's a very, very good idea.
In fact, that is something that has been done by the through the Advice Now guides. So just to give a plug for them, that's what makes them so accessible, I think, is that they put complicated legal concepts into plain English and then give some examples of what people have done. So I always recommend those to people in a MIAM.
And I think someone's posted a link in the chat, and they're certainly available from the Advice Now website. I think there's a small fee for them, but it's really isn't very much in the great scheme of things. Karen, what would you do?
A couple of things. I did put the Advice Now link in, and Mary's put it in again. I think back in the day, we certainly understood that when people were divorcing or separating, 77% of them made percent of folk made their way to a lawyer. We perhaps don't think that's happening now. I do think we need a central, reliable, perhaps government endorsed website for people for information, but make a great plug for Advice Now. I think for me, some of the worrying aspects in the research generally was around pensions and the unfairness, I think, particularly to women. I understand that there is still this view, it's my pension, I will leave with it. And we can see, and particularly where there are still young children and perhaps even children in their 20s that need a roof over their head, that wives are then perhaps left clinging onto a dilapidated property that needs rewiring and a new roof, while perhaps husbands are leaving with pensions. I give a plug to the PAG2, which has now landed. And again, we can put some useful links in the chats there. Advice Now has a layperson's guide to pensions on divorce, which again, I think will plug some of that information, and perhaps even for those of us that are the professionals here is perhaps worth reading, because it is distilled into language that we can all understand. One of the cases in the research that I was really concerned about, and perhaps I can just touch on this in terms of outcome documents, was a case where the husband and wife had agreed that when the husband retired, he would give the wife some of the money from his pension. It wasn't documented. And during the research, he said, well, I'm sort of half hoping she might have forgotten about it. So there's no attachment order, no pension sharing order. And I think that is a real concern. There is a lack of information and understanding about pensions. It's a difficult area even for us as professionals. And I suppose, again, looking at that area in particular, is trying to encourage, persuade separating, divorcing couples to commission a pension report. Something I heard this week for the lawyers here is that some of the PI insurance, where there is a CEV of 100,000 or more, now requires that lawyer to get a pension sharing report. So this is perhaps just a nod to the lawyers here to go back and check their PI insurance. But how we marry up doing that work, the cost of it, the understanding the implications, particularly where people are dipping in and out of professional services. So there's an awful lot to sort of worry about. We try and give good information. People don't always have lawyers. They might be dipping in and out. They are relying increasingly on one professional. That's often the retained mediator, or perhaps using under the resolution together model, the same lawyer. On outcome documents from the research, we could see that one half of the mediating couple had a consent order and the other didn't. There are some options here for the mediator to prepare the consent order. Again, very helpful information on, I know, the resolution website. If they are also a solicitor, is determining the mediation retainer and then doing it as a single lawyer, and working with lawyers that operate the resolution together or same lawyer model, and then referring mediation clients on there. Because for me, that was another concern and something that as mediators we can do something about.
Thank you very much. Go on.
David, thank you. Just want to add on, because I'm a mediator and I work with BINA, strangely. One thing we obviously always refer to Advice Now, and always obviously tell clients to go seek independent legal advice. Where we have clients who are legally aided, obviously there's a scheme there where they can access that 1 hour free advice under the mediation certificate. What we find in our area is that the options and the availability of that advice can be quite difficult in terms of people who are in legal aid mediation being able to access and find a solicitor that might provide that advice. But I think we're probably joined in trying to sort of see if legal aid could fund up a bit more to support us. So I think maybe that an extension of that service, or making that worthwhile and available, particularly for those most vulnerable on legal aid.
Thanks, Ashley. Can I continue my theme of jumping on people who are not on the panel and asking a surprise question? Denise Ingemels, you are the writer of the SPIPs. You're a mediator, but a non-lawyer mediator. What do you think mediators can do in terms of making sure the participants have legal information?
Well, I think I agree with Ashley, you know, that it's impossible to find a lawyer, virtually impossible to find a lawyer that will give that time in addition to, you know, when you have people who are legally aided. So what happens is, in my experiences, is a lot of people will come into mediation and they'll say, I can't afford a lawyer. And trying to convince them that actually it's worthwhile spending that money in getting legal advice. You know, it's almost like the other way round to lawyers convincing clients to mediate. It's having people coming into mediation, especially in the service that I work for, which is sort of in the not-for-profit sector, particularly there. It's really trying to convince people that, you know, it's actually worthwhile them getting legal advice. And they come in and they really, quite frequently, as I think has been put in this report, they really don't think that the pension is something that they should be looking at. And so I suppose, excuse me, in terms of mediation not being what they expected, it could actually be that they're not expected to, challenged is perhaps a strong word, but they are challenged in that they quite often come in thinking that things are going to go a particular way. And when you're giving them legal information, but not advice, they're really not keen to take that up, particularly if it's not in their favour. I mean, I just think that it's, as you said, Dave, with the lack of legal aid and having lawyers working alongside mediators or referring to mediation, that, you know, we've taken a real step back. But I think that with all the options that are open now, it's maybe about publicising all those options that are available. You know, it's not just mediation, you've got hybrid mediation, you've got, I mean, I won't go into all the various different options, but you've got lots and lots of different options for people. It's very much now that there's a real lack of money, I think, for people. And so it's really about convincing them that any money that they spend is actually worthwhile.
Yeah. Well, I mean, certainly I've done mediations where people have got stuck, and I have, with their agreement and their drafting, got an opinion of a barrister for them to feed back into the mediation. But you know, that's not necessarily cheap as chips. Can I turn, John, I know you've got to go relatively soon, but can I ask you and Rachel, where do you think we as mediators need to go from here? And is there a call for any further research? Has the project actually thrown up more areas we need to investigate? Rachel, do you want to go first, please?
Yeah, I think John actually has gone.
Oh, yes, okay.
So I will. I guess I'll speak.
It's all down to you.
I know. The thing is, with any really good research project, is it throws up a million more questions, a million more gaps where we need more work. And I know when I went to the launch of the Fair Shares project, they said there's loads they want to do with the data, and there's loads more data they want to collect. They just then, as we always find, we have to then apply for the funding, and unfortunately things take time, and unfortunately things don't always work out. I think in terms of just there's obviously work to be done in terms of pension awareness, but if we think about mediation specifically, I suppose what I'm personally interested in is, you know, how do we understand family mediation? What role does it have today? And I think this really links into what we were saying on, well, what are mediators to do if someone can't go get a lawyer and things? I do wonder if we need to actually just have really open discussions about what is happening and perhaps actually rethink how we approach things. So I know we mentioned neutrality earlier, you know, and that's obviously right at the heart of family mediator practice. And I completely agree with that. But when I spoke to mediators, you know, they were very open that mediator neutrality doesn't stop them from acting when there's a power imbalance. And if a mediator didn't do anything because they were neutral, there wouldn't be much point to that process as a whole. So I guess I worry that we often understand concepts like neutrality and neutrality, I suppose, information and advice is very binary things. Is it actually better to understand these things on a, I guess, a continuum? And then from that, we can start to think about what is actually appropriate. The next big thing for research, I think, is what is happening in practice. I think we have promising signs that mediators are doing more and trying to do more, trying to provide that flexible service that clients often want now. But we are at a period where mandatory mediation may come in the next few years. We don't have the Ministry of Justice's response to the consultation yet. What would that look like? Do we feel mediation is ready for something like that? Do we have the numbers of mediators is a really big question I have of if suddenly everyone was tunneled into mediation, do we have the capacity for that to work, or would that cause delays? So I think that's another big thing. And I guess as a final point, I do think there's a lot to be said about different mediation models. The mediators I spoke to, for example, quite a few of them said they would turn to shuttle mediation. But what we find with mediation models is they cost more money. And so if you are that very everyday case where you have extremely limited funds, those aren't viable options for you. So what does the standard mediation model actually look like in practice, and what can we build onto it in a way that makes it appropriate, that makes it still mediation? But yeah, that's probably enough of my ideas. I could go on for ages.
Thanks, Rachel. I wondered if I could ask the other panelists in turn, how can we make lawyer-supported mediation more affordable? Karen, do you want to take that first?
Well, we have what we call hybrid or integrated, where we bring lawyers and other professionals by agreement to sessions where that's helpful. I suppose in terms of my practice, I suppose there are several things. One, the mediator can perhaps do a lot more of the case management, which means perhaps the lawyers are doing less of the work so that we haven't got 3 expensive meters running at one time. If we're having what I call settlement meetings, all the preparatory work is done so that we're making best value of that time. Again, we'd often have 3 professionals there, and there are costs implications there. Is there a model perhaps for a package for clients where mediators and the retained lawyers perhaps provide a service at a price point that clients know what they're getting, who they're getting, and what that's going to cost? I think for me, the research sort of shows that there's still a great deal of misunderstanding by the public about what mediation is or it isn't. I think with lawyers, we have to be sure that they are referring to mediation, perhaps cases that are or might be suitable. We can't just be the place of last resort because there are impoverished folk, and so we'll just send it to mediation because there's no other process to help them. But I think the research shows the important connection between lawyers and mediators, and we have to find a way, I think, as a wider profession to try and help people at a price point they can afford with suitable and appropriate services. Very, very difficult when there are such financial constraints. I see Nigel in the chat put that Resolution is lobbying for some form of return to some form of legal aid. I know from my time being on the National Committee, we were looking at perhaps a government voucher scheme where people could perhaps use it for mediation or early legal advice, or possibly even emotional support, because we know that's often the third element that people need. If we've got people on the panel or elsewhere that have the answer to this question, please do speak now before 11:30.
Well, I've got a slight concern about legal aid coming back. Not that I don't think it should, but it's likely to be for a relatively short number of hours covered, maybe two or 3 hours. And the great problem for a lot of practitioners was the means assessment that goes into, I see Beverly shaking her head. You know, it can take an hour and a half to go through the forms, get the evidence that's required to avoid having a dodgy audit. And therefore, a voucher scheme is going to be far, far better than a means tested. And I think we all agree that the mediation voucher scheme has been a success because it's relatively easy to administer. Mary, what are your cost saving ideas?
Well, I was just going to say on that point that I think the voucher scheme hadn't really come in properly when the Fair Shares report was being researched, and I think that's a really important point to take away from today, that if you are going to do additional research, then it will be really helpful to us and to whichever government might be administering it in the future to really get to the bottom of any impact that the voucher scheme has had on the statistics that the report produces, because I would imagine that the report isn't really reflective of that scheme, which has only been in for a couple of years. So that's just one point to make. Someone, Rachel Blakey has mentioned Resolution Together, and I think it's important to just point out the evolution of the one lawyer, two clients model, which of course we as mediators can really capitalise on, because if we're working well with a couple who come to a solution within mediation, that can then be referred out to the one lawyer, two clients model to carry out further assessment and do the work for both, and that therefore should inevitably cut down on their legal costs. So that's something I'm already doing with my clients as a mediator when I feel that it's suitable. At the moment, possibly what would happen is if one client in mediation has one lawyer, that one lawyer would draft up the document and then send it through to the other person, who is often a litigant in person, therefore doesn't have access to legal advice and probably won't get access to legal advice because of cost implications. So having that one lawyer, two clients model is a potential way of creatively introducing the legal aspect. I do think the government needs to get involved a bit. The voucher scheme is quite exclusionary. If you're older, you don't have children, children that you're going to be talking about, then you're not going to be in the scheme, which I think is quite, not very diverse. Obviously people that don't have kids anyway, they're not included in the scheme and so forth. So I think really the government needs to be re-looking at that scheme and making it far more accessible to people, and perhaps extending it. So £500 is brilliant, but there could potentially be an element of legal advice in that couples could go off, or families could go off and get some legal advice. So there could be a lot of creativity around that scheme, and I think it would be really helpful if the academics or academic, as we've now in the room, could do some further work on that, because we will only get it if we can produce the research to show that it's working.
Yeah. Elaine, what do you think on cost efficiency?
I agree with everything that Karen and Mary have said, of course, goes without saying, and particularly following up on your point, Mary, about being creative. I think that there's obviously more training that's needed for lawyers about what can and can't be done in mediation. And I come across that all the time. I think hybrid mediation is brilliant. It ticks so many boxes. I'm always very interested to meet with the professionals only for that professionals meeting that we have in hybrid mediation, because that is quite a revelation. So many times I've found that I'm the most up-to-date person in the room about what's going on, because the clients haven't actually accessed their lawyers as often as anyone might expect. And part of the reason for that is cost, of course. So I do think that thinking about how to be cost effective in each particular case, there is a real argument to say that on a case by case basis, could the mediator be communicating with the lawyers more throughout the mediation process to make sure that they are kept on board, and that then what you do ultimately is the most cost effective thing? Because it is that thing about, as you were saying, about making sure that enough preparation has been done for that final negotiating meeting. Because what very often happens with the hybrid model is that participants will decide to do as much of the donkey work that they can themselves. And it's just to make sure that all of that planning is joined up, so the lawyers are all on board with that. And so when you come to have the negotiating meeting where the lawyers are involved, that's done in the most well-prepared and cost-effective way. So it actually just boils down to far more communication about this and information.
Okay, we're drawing to a close, and I'm going to ask a final question in minutes of those on the panel as to what they're going to take forward from the report. But is there anything that anyone wants to say, not on the panel, either by way of comment on the report or anything you've heard today? Denise?
I think it's it's not just about us communicating, lawyers, mediators communicating. It's how we communicate that to clients, because they have a perception of what is expensive, because that means them laying out money that perhaps they don't have now, and really not realizing that if they don't spend it now, it's going to be very costly for them in the future. So it's really about how we all join up to get that message across to the divorcing population, that this is simple. It needs to be something simple. It needs to be a really clear message that this is the most simple, most straightforward way forward for them. So again, we go back to that hub, don't we? That source of reliable information, I think, because there's so much information out there. How do they decide what's right for them?
Yeah. Okay, Mary. So just as the final question, what are you going to take forward from this report?
So one of the points made right at the start, I think in the video, and also Rachel really focused on it, the fact that people are not, according to this research, getting the outcome that they're expecting. So I think that's really, really, really pivotal, that we really focus on expectation management for our clients, and education. So putting stuff out there, really, really sharing resources, sharing information, making information accessible to the public, and also, checking in with our clients to really just manage that their expectations are that they understand what they're getting from this service, and flagging anyone else in the team that needs to be made available that can provide that resource. We're not meditation, we're not counsellors, we're not therapists, we're not reconciliation, all of that stuff.
Thanks. Elaine?
I think for me, it's really important that we are aware of the criticisms of mediation and where it's not working, and we really focus in and turn our attention to those particular areas and how they can be addressed. But ultimately, again, I completely agree with Mary about expectation management and about education, about information, and joining all of that up, as Denise has said, to involve everybody, I think is really important. So it's, again, I suppose if you ask me one important thing. It's just to give people options, to do the safest thing and to give them options and not just direct everybody into court, which we know is just a failing process at the moment.
Although sometimes you can have too many options, can't you, as a consumer? Yeah. Rachel, what would you like to?
I mean,
What
I've learned is
it's more relevant for you, because what are you going to do?
yes. Well, what I've learned is there's a lot of research that mediators would like, understandably, and I would be really keen in doing a lot of it. So if people do want to, you know, talk about different ideas for research, do just drop me a message, or I'm sure John would be as well, Emma, etc. I think Mary and Elaine have put it really well, of expectation management, giving people options. Training and accreditation, I think, is something that we need to think about going forward as well, that if we are going to perhaps change certain things, or allow mediators to act in a certain way, making sure that's properly embedded in that training and accreditation process. I'm aware that's something the Family Mediation Council is, of course, doing with their standards review. But then I think it's really important we all contribute to those discussions. This has been a wonderful session. I'd love to hear people's different views and collaboration, and just, I think, keeping that collaboration going, not only within mediation circles, but mediators and lawyers and academics and so on, I think is really important.
Thanks, Rachel. And finally, Karen.
Oh, my takeaways. I've got a list as long as your arm. Collaboration, absolutely. It takes a village to raise a child. It is, I think, about professional connections. We need some more research. I'm delighted to see Mavis here. I know that you feel we need a proper study of the different models of mediation, why some work, some don't, etc. And Rachel, we're really pleased to have you and John within this community. And of course, we have a pool of talent for you to dip in and out of as you wish to. I think for me, actually, is preparing clients for mediation, which goes beyond a conversation with me. And I put into the chat, for example, Rhiannon Ford, who works near to me in Surrey, who has guides and videos, etc. I think that may just help people understand what it is, what it isn't. That was one of the key findings. And of course, levels of expectation. So that for me, I think is going to be my immediate takeaway from today.
Well, thank you. And I'm just looking at the chat, and Rachel has very kindly put the link to John's work on children's experiences on separation, and a reminder to everybody about her forthcoming book on the mediation profession. And that's going to be a fascinating read. So do keep us informed, Rachel, when it comes out, please. Can I thank all the panelists, Karen, Elaine, Mary, Rachel and John, and also to Emma for putting together the video, for everyone who's put this together, and also for everyone attending today. Thank you very much indeed. Bye-bye.